So both the Jacob Zuma corruption case and the Senzo Meyiwa murder trial have ended in postponements. The case against the former president will return to court on the 17th of May, pending his reconsideration application against prosecutor Billy Downer in the Supreme Court of Appeal. In the Meyiwa matter, a defense lawyer claims that they didn't have sufficient time to prepare their client, leading to that case being delayed until at least today. To get you up to speed with what else you need to know with both matters, bring in legal analyst Ulrich Roux, who joins us now via our telephone line. Ulrich, it's great to have you on the program. Thanks as always for making time. I want to start with the Zuma matter and hone in on what took up most of yesterday's proceedings, and that was discussions around this reconsideration application. Let's start by you just speaking plainly or broadly what that is, but more importantly, get us in on whether you've come across any case where an accused has used this legal avenue and the outcome has been in their favor.
Sorry, you just broke up there. If you can just repeat that.
I was just hoping, Ulrich, that you'll be able to outline what a reconsideration application to the SCA entails and whether or not you've come across any accused who's used this legal instrument and had the outcome in their favor.
Yes, certainly this is a first for me, and it is precedent setting if it is successful. So what Jacob Zuma's legal team is doing now is he launched a petition to the Supreme Court of Appeal in which he requested the Supreme Court of Appeal to have Billy Downer removed as the prosecutor on the matter where he is the accused. That petition was dismissed by the Supreme Court of Appeals. In other words, and it was dismissed with costs. They said that there's no merits in the petition and that there's no chance of a higher court coming to a different decision that Billy Downer must indeed be removed. And he is now exercising his right in terms of the Superior Courts Act to approach the head justice of the Supreme Court of Appeal, Justice Meyiwa, in order to reconsider that decision made by the judges who serve under Justice Meyiwa. So it is certainly an unusual step, if I may call it that, but it is a recourse that is available to him. But in my opinion, the chances of that being successful are very slim. 3 judges have already considered his petition application. They have dismissed it with costs, confirming that there's absolutely no merits in that application. Now he's gone to their superior, so to speak, and asked Justice Meyiwa to reconsider that. Yes, it is a recourse available to him, but I don't think it can be successful. And certainly we don't see this very often in the legal fraternity.
Yeah, the former president is essentially asking the SCA head to see whether the people who work under her actually were right in the judgment that they came to, in their dismissal. But what I found very interesting is Judge Coon yesterday saying, yes, the former president is not necessarily abusing the legal system. It is well within his right, but he's also not entitled to an indefinite postponement. What that has done is forced the High Court sitting in Pretoria to have the case postponed to a specific date, which we now know to be the 17th of May. But I can't help but wonder whether the SCA head, which is Mandisa Meyiwa, is now kind of forced or pressurized to have her decision made by then.
Yes, it's the High Court in Pietermaritzburg, of course. But
yes.
Yes, so, a court will only grant a postponement if the court finds it, and this is in terms of the Criminal Procedure Act, to be absolutely necessary and expedient. Now, what that means is that the court won't grant a postponement if it is going to cause an unnecessary delay, and it also won't grant a postponement without proper grounds for that postponement. So Judge Coon weighed up these different factors together with the fact that, remember, this matter was certified trial ready in 2018 already. So this trial could have started 4 years ago already. As a result of the numerous postponements and interlocutory applications, it has, of course, not started yet. But he has said that on the 17th of May, if Justice Meyiwa has not reached that or made that decision yet, then it will be postponed for that decision. He has said that Jacob Zuma is entitled to exercise his full rights in terms of his appeal options and taking the decisions on appeal. And this is not an abuse of the system because he's entitled to it. But having said that, I think the chances of success are zero. He's already got a cost order against him where the SCA dismissed his petition. And I cannot foresee the Chief Justice Meyiwa going against 3 of the judges in the Supreme Court of Appeal and saying, well, they in fact made a mistake, and I in fact agree with Mr. Jacob Zuma. So, yes, he's entitled to it. I think it's debatable whether it is an abuse of the system because, in my opinion, there's slim chances of success.
Sure.
But certainly it is a step that he can take. So, once again, if that decision is not made by the 17th of May, then it will be postponed for that decision. But I do think that it will be made. It is a matter of great importance in terms of what society perceives of this matter. It is a previous head of state of South Africa. There's obviously substantial interest in it from the public at large. So it is in everyone's interest, including Jacob Zuma's, for this matter to be finalized as soon as possible.
Gotcha.
I think that the Supreme Court of Appeal will agree.
Yeah, I just want to speak very quickly about the Meyiwa trial as well. I mean, what we saw take place there yesterday is that matter being postponed on the basis essentially of counsel for one of the accused saying that they're not ready. How unusual is that?
Once again, when a court considers an application for postponement, they must take the following 2 factors in account, and this is in terms of the Criminal Procedure Act. Is the request for postponement a reasonable one? Is it an expedient one? So will it not amount to an undue delay? And is it absolutely necessary for the postponement? An accused person has a right to a fair trial, and that includes proper legal representation. So if I did not follow that trial yesterday, but if the legal representative stood up and said, well, I've been briefed at a very late stage and I have not had an opportunity to peruse the content of the docket properly and to take proper instructions, and accordingly I cannot defend my client adequately today, I need more time, then the court would have considered that, and obviously if it was granted, the court would have deemed that to be a reasonable request and a necessary one in order for the accused to have a fair trial.
All right, and we know that case is back in court today. Ulrich Roux, always appreciate your time, sir. Thanks very much indeed. Ulrich, of course, is a legal analyst.